asked, now what is the status of the cases facing Deputy President William Ruto, former radio journalist Joshua Rapsang, and of course President Uhuru Kenyatta? Thank you so much for talking to us here on KTN News Center. As we speak, what is the status of the case? Because we know that the cases against President Uhuru Kenyatta, his deputy William Ruto, and former radio journalist Joshua Rapsang were dropped, and when the court was dropping the case against Deputy President and Joshua Sang, they said that the prosecution team actually failed to provide more details, actually more evidence. But when it came to the case against President Uhuru Kenyatta, the prosecution actually dropped the case, saying that the Kenyan government actually failed to provide more evidence so as to proceed with this case. But as we talk right now, what is the status of these three cases?
Well, thank you. The ICC in prosecution and pursuit of justice for victims ordinarily depends on state parties' cooperation, or the cooperation of the states as legal persons within the context of the treaty itself. The problem that is there is that there is no established police unit out there in the world that executes the mandate of ICC directly, so that then the ICC continues to rely on the goodwill, so to speak, of state parties or the state within which those that will be prosecuted or suspects are domiciled or they live. And therefore, there's a lot of activities preceding a person's arraignment before the court. The willingness, the political will, and the context and environment within which the execution will be required. For instance, if the government is not cooperative, then it will be very difficult for ICC to be able to extradite or get a person to appear before it or before the court. The context of these proceedings, which now seem like we have three contexts, one being the case against the sitting president, which was dropped on account of an accusation that the government did not provide information otherwise, which the court wanted, or the prosecution, so as then to mount, to make a decision or mount a credible case. As matters stood then and now is that there was no credible case, so as to continue with the prosecution. The case was therefore withdrawn on account that in the event that evidence is obtained that otherwise crystallizes into the weight so as to pursue it, then that can be brought again. The second case of Sang and Deputy President, again, had its challenges. One of it was, of course, accusations about the interference of witnesses, and therefore that was also dropped, or it was withdrawn, but again, not because of an acquittal, because an acquittal means can be brought back. It can be brought back in the event that further evidence obtained. Now, because of the issues that emerged within the prosecution, or during the course of the hearing, that there was interference of witnesses, there must have been pre-authorization by the ICC chamber that Fatou Bensouda, or the lead prosecutor, could proceed and make investigation on that issue. And therefore, that is the basis upon which Fatou Bensouda is pursuing the three persons who are Kenyans by citizenship, and it's proposed that they are domiciled in Kenya, and the request therefore for them to be taken or to be extradited to the court. This therefore is part and parcel of the same continuation of the proceedings, being that they are the main cases, and they are cases that emerged as a result of the proceedings, being that there were witnesses who were supposed to testify or would be witnesses, and there's an alleged interference of those witnesses in order then that there will be obstruction of justice. That being the allegation, it is an allegation that can be investigated by the ICC, and then prosecution can ensue therefrom.
So Akili, yes, are you saying that should the three, in case the three are arrested, that is Paul Gisheru, Philip Kipkoech Bet, and journalist Walter Barasa, In case the prosecution goes ahead and arrests the 3 Kenyans, are we likely to look at a case where this case is the case against Deputy President and the President of the Republic of Kenya and, of course, the former radio journalist? These cases will not again emerge in terms of starting a fresh prosecution?
Not at all. The cases can emerge. In fact, from the reading of the movements and the transactions that are being taken up by the prosecutor, it means that these cases are still alive within the context of the prosecutor still in investigation. The prosecutor seems to be to have the intention to still pursue these investigations and probably fill the gaps that were there. The alternative to it is because they could not get the bigger pursuit of those that would have been main suspects if the cases, of course, had proceeded, then those that were part and parcel of the interference of the cases, the 3 gentlemen who have been named. And therefore, it means, therefore, in the event that the collection of evidence or the pursuit of evidence crystallizes into a formidable amount of a case before the ICC, it means that these cases can still be brought. So criminal cases do not have the limitation of time upon which you can say after 12 years, after 15 years, after 20 years, after 50 years, the case then is limited in time and therefore cannot be prosecuted. So this is something that will continue to be alive within the books and the pursuits of Fatu Bensouda or the prosecution, whether it's her or someone else within a different term of another officer at that time. But still, it's a possibility, a constant possibility and threat that these cases can still be mounted afresh. However, for purposes of what then transpired, there must be an imminent possibility or imminent, there must be evidence, credible evidence by the prosecution that these 3 gentlemen then participated in the interference of witness and the accusation that are made against them. What must be important probably to the public to note is that this has nothing to do with the main cases that are going on, the side issues that came up within the transaction as was being pursued by the prosecution.
All right.
The bearing, however, on the main cases is that then that will be evidence that yes, there could have been interference.
So what is the process of extraditing the 3 to the Hague-based court? And owing to the fact that last year in December, let me just get it right for you, it is that the High Court declined to issue an order to execute the arrest of 2 specific people, that is Gisheru and Bet. Well, this year, we saw Walter Barasa actually saying that he's ready to go to the Hague-based court to defend himself. So what is the process of extraditing these 3 to the Hague-based court?
Well, there's ordinarily a very elaborate process because there's administrative aspect of the state itself, but more importantly is that the crystallization of that is an order that has to come through the domestic processes of the hierarchy of court. One has a right to go to court. Rather, the prosecution domestically having been requested, or the state have been requested, will have to pursue through its prosecutorial system here, so that then eventually the court authorizes the extradition itself through the court systems. The victim or the suspect has a right to present himself before court locally and give reasons why he does not consent to that extradition, the extradition, and therefore these are very elaborate proceedings. Remember, the law that is applicable is the law, the domestic law and the constitution, which is not necessarily the adoptable law by the ICC. In fact, at the ICC, it is very clear that it is not guided by domestic legislations or domestic laws of a particular country. But the conflict arises when then the protection of the person is weighed against the demands of the treaty. Remember that the Constitution is supreme in the context of the jurisdiction of this country and the courts here. So they will weight the Constitution higher than any other law, and therefore any international legislation or treaty that was signed becomes subservient, or it does not supersede the provision